Now, one person we did hear from today for the first time, Karen Reed herself, doubling down, of course, saying she did not do this. She wants to know who did.
Said it feels we're the only ones fighting for the truth of what happened to John O'Keefe. And me and my family and my attorneys and my team have marshaled every resource to get to the truth. It just feels like no one else wants it.
Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
And no, she didn't do it. No, she didn't do it. This is an innocent woman. She didn't do it.
I tried to save his life.
Yeah.
I tried to save his life at 6 in the morning. I was covered in the only one trying to save his life.
Why'd you admit to it?
She didn't admit to it. She didn't admit to anything close to that. Nothing close to that. And you should know that.
That was like 3 or 4 times she admitted to it.
No, she didn't.
That's not true.
She asked a question. She asked a question, which is very different. She didn't admit to anything.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Okay, how is everybody? We better get to this hearing pretty quickly. My apologies for being a little late. I'm this cat sitting, my bestie girlfriend's cat.
Now sitting in the Norfolk Superior Court within the Fuller County, Norfolk, Rodney, if you attend, shall be heard. God save the Commonwealth and the Court, and the proceeding for it now set.
Judge 22-117, the Commonwealth versus Karen Reed. So identify yourself, starting with the Commonwealth. I'm not the Commonwealth. Yes, Ms. Natalie Becky, you're on our phone. Yes, Ms. Clinton. Yes, Mary Robert Martin, my word on behalf of Karen Reed, who sits to my left, and co-counsel David. Yes, Ms. Margaret, yes, Ms. Jenny, yes, Ms. All right, Mr. Lumber, I will hear you on your motion. Thank you, Your Honor. May I use the podium? Thank you. Judge, there are 2 central issues. There is not one for amplification, there is one for recording.
Yes, Your Honor.
I just want to make sure I hear it.
At a day like this, I'll keep my voice.
Okay.
Thank you, Your Honor. There are 2 central issues that are raised by the motion to dismiss and the supplemental affidavits that have been filed on behalf of Ms. Reed. The first of them is whether or not there is strong and I contend uncontradicted evidence that the jury reached a unanimous decision, even if it wasn't formalized into a vote or into a polling announcement to the court. But it's strong and uncontradicted as a result of the juror declarations that were made through counsel to the court, sworn to by counsel, that the jury reached a unanimous verdict on 2 of the 3 counts of the 3-count indictment. So the legal issue is in the face of that evidence, whether or not Ms. Reed can again be re-prosecuted for the same offense by the same prosecutor who we contend failed to prove her guilt to even 1, much less 12 jurors in trial 1. And when I address that, Judge, I will make a proposal to Your Honor that's close to the procedural pathway used by other judges in cases similar to this, in terms of just how do we transform representations in attorney affidavits into hard proof that we believe will convince the court and in fact believe that will convince Mr. Lally and the district attorney's office that that jury, the jury that Your Honor described as an extraordinary jury, reached a decision. It will be consistent with their jury service and consistent with respecting that jury service, that we give at least the jurors who are willing to appear before the court anonymously the opportunity to inform the court that this was a final unanimous decision. It didn't get further deliberation. It was a unanimous decision on 2 of the 3 counts, and the impasse was in fact on the 3rd count, which was count 2, and lesser includes the manslaughter count. The second of the legal issues that I want to address, and they both together center on the double jeopardy clause, its unique history, and it's discouraging, if not deterring, if not prohibiting second trials when there's any rationale that would justify the verdict of the first trial, the first jury, or the continuation of the first jury's deliberations, is whether or not, now that we have evidence that the jury was not at an impasse, evidence that was not known to Your Honor at the time that you ordered that they be disbanded and ordered the mistrial, evidence not known to Mr. Lally and the prosecution or the defense, that in fact the note they wrote to Your Honor after the TUI charge on July 1 was not unambiguous, as Mr. Lally wrote in his pleading. It was ambiguous. It was subject to 2 constructions. One, that their impasse covered all 3 counts, and therefore would lead ineluctably to a mistrial declaration, or 2, that the impasse was on 1 count with multiple lesser included charges, but did not encompass counts 1 and 3. Your Honor didn't know what was in the jury's mind, what was in their mind when they authored a note to the court, neither did counsel. But the issue now, and again, it's in the context of double jeopardy, which is such an historic and important clause that was enacted by our founding fathers to give them some protection against the sovereign at that point, the king, against simply choosing to mistrial prosecutions that weren't going well. And the founding fathers wanted citizens not to have to face re-prosecution. They understood the ordeal and anxiety and risks of having to prove to a second jury what they had proven to a first jury, which is that they were not guilty. And so the real issue here is legally, what do we do when we now know that jurors are declaring to the court that they believed they reached a verdict of not guilty? What can we do on August 8th, if I've got the date correct? 6 weeks after the July 1 trial that Your Honor presided over, a lengthy trial with an exceptional jury. And I contend, Judge, that we can't just accept a fiction that the jury was at an impasse on all 3 counts when 4 jurors are saying to you through counsel they were not, and a 5th juror is saying to counsel indirectly they were not. We have to embrace the fact that these are now facts. Yes, they come after the end of the trial, but it doesn't mean that there's not some procedural pathway to integrate those facts into Your Honor's decision-making. And the second one, the manifest necessity issue, has got a lot more SJC and Supreme Court guidance. It's been the subject of lots of cases. We're walking a little bit down a pathway that has some precedents about jurors and they're being reconvened, but it doesn't have the clarity of the precedents regarding the manifest necessity standards, guidelines, principles that will address that. But here what we know is that 4 jurors reached out to defense counsel. Jurors A, B, D, and E, I think is the way they've been described by Mr. Jackson, who received calls from 3 of the jurors, and Mr. Yannetti, who received a call from 1 juror and talked to somebody who himself or herself spoke to a 5th juror. We also have the corroboration, not just internally, where these 4 jurors are essentially saying the same thing. We reached a decision. We didn't announce it. Some said we felt bad about it. We didn't know what to do. But they're internally consistent and not self-contradictory, and that makes them more trustworthy. They corroborate each other, and I contend that the voicemail left on Mr. Lowry's phone, which he responsibly shared with counsel and shared with the court, essentially saying this was probably one of the 4 jurors, but we don't know for sure, says essentially the same thing. We reached a decision that Ms. Reed was not guilty. Murder, the most serious charge that can be brought, a charge that would imperil her the rest of her life if there was a conviction. Other jurors tried to reach the prosecutor. They didn't succeed. The prosecutor made a decision that he couldn't promise anonymity, which every juror seems to want, and that's understandable given the level of media and public attention on this case. And I understand the court gave them discretion, and Your Honor made an order that they were entitled to anonymity. The public interest did not weigh the interest of the jury in anonymity. But we now have the declarations of the jurors through the defense counsel. We have a voicemail of one juror through Mr. Lally. We have emails of other jurors who only wanted anonymity as a condition precedent to talking to the prosecutor. This case, because it has catalyzed so much publicity, it's plausible to believe, if not compelling to believe, that other jurors who sat through so many weeks of testimony, this was probably one of the monumental central events of their life. Not many people, certainly not people who go, other than people who go into military service, have opportunities to serve their community like these jurors did. Not one of them, to our knowledge, has picked up the phone to defense counsel and said, those jurors that you're memorializing in affidavits and in motions, I don't agree with that. No one has called the district attorney. Nobody has emailed anybody. Nobody has called Your Honor through the court clerks. Nobody disputes, in other words, none of the 7 or 8 jurors that are not, represented by the series of affidavits of defense counsel dispute the truth of the representations made by counsel. We don't have certainty. We only have the reasonable inferences from the absence of other declarations, which is that this jury was unanimous in its acquittal of Ms. Reed on counts 1 and 3. So then we get to the legal issue, and again, as I tried to say, the legal framework here, the landscape is not quite as crystal clear as it is in standards of manifest necessity, whether or not double jeopardy permits a re-prosecution in the context of this unique case. But what we have is court decisions saying, for instance, what constitutes an acquittal is not to be controlled by the form of a judge's actions. We're not bound by labels. That's the SJC in Commonwealth versus Taylor. We have Justice Ginsburg joining Justice Sotomayor and Justice Kagan in a dissent in the Bluford case, saying, in ascertaining whether an acquittal has occurred, form is not to be exalted over substance. And they are making that point. I mean, I've done this for 52 years, and the procedures and form sometimes governs. And it's the recognition that double jeopardy is different. For instance, as I'll get to in the manifest necessity phase of the argument, all of the courts put a heavy burden on the prosecutor to justify a mistrial, to justify a re-prosecution. Ordinarily, I'm used to the burden speaking on me as a defense counsel. I'm used to having an affirmative obligation to lay out for an appeals court exactly what I want. But in this unique area, the disincentive to re-prosecuting somebody, the same prosecutor for the same offense, when there's evidence of an acquittal or evidence that the jury wasn't at an impasse over all counts is so significant, it's so core to our values, that they put the burden on the prosecutor, and I will get to the cases that support that, what I call a central proposition, which is, where's the default? Is the default from not asking the jury about these other counts, that Ms. Reed goes to trial again? Or is the default instead that the prosecution simply cannot again re-prosecute her when there was not manifest necessity in the first place for the counts 1 and 3? The Supreme Court 67 years ago, and I remember it because it was the tail end of the Warren Court, and it revolutionized criminal justice, and it talked about Miranda rights. Nobody knew Mr. Miranda back in the 1950s. Gideon gave right to counsel rights. Matt v. Ohio extended suppression remedies for Fourth Amendment violations. These were all unknown until the Warren Court. The Warren Court, in the case of Green versus the United States, and it's in our pleadings, said, and it's important, that double jeopardy was designed to protect an individual from being subjected to the hazards of trial more than once. That the state, with all its power, should not subject a citizen to the ordeal of living in a, quote, continuing state of anxiety, as well as enhancing the possibility that even though innocent, he may be found guilty by a second jury. So what do we do in a world where we have facts not known on July 1 that are known on August 8? And we're not, this is not completely novel territory. For instance, the First Circuit, the Federal Court of Appeals, it's 11 years since the Boston Marathon bombing. And they're still dealing because of capital punishment with whether the punishment should be life or death for the Sanaya that was arrested and survived. And they recently, in a lengthy opinion of over 100 pages, said, bring back these 2 jurors where we have a principal basis to question their impartiality. The SJC just 4 years ago, in a case dealing with a lawyer's allegation that there had been a racial statement, it's called the McCallum case, 485 Mass 790, said to the defense counsel, the judge will authorize you to recontact that juror and get an affidavit. And if there's any skepticism regarding the truth of the affidavit, we will have a hearing and make decisions. The nation was affixed to the Murdoch case from South Carolina, where a lawyer was accused of killing his family. And there was evidence recently, according to the media, that a clerk spoke to a juror, and the judge convened a hearing, questioned the people who were connected to it before in order to make a decision. In other words, regularly, judges who receive reliable evidence that there was extrinsic evidence, that a marshal talked to a juror, was a juror biased, was the questionnaire fair, did something happen during, did the jurors access the internet when they were judicially prohibited from doing so? Courts reconvene hearings, and I can test that it can be done anonymously, doesn't have to ineluctably lead to the identity of jurors. And we're going to ask the court to do just that, because without in any way diminishing the centrality and the importance of an impartial jury that tells the truth on voir dire, that's not ethnically or racially biased. There's nothing more central about making sure that jury was not influenced adversely by something from the outside or even by something from the internal discussions that reflected on a juror's racial and ethnic impartiality. Why isn't an acquittal entitled to just the same kind of deference? You know, we have not evidence that the jury was not impartial or that they were influenced externally. We have hard evidence that they reached a decision. We're not asking to have any inquiry, whether by counsel or by the court, into the content of deliberations, into their reasoning, into all of those matters that are forever private. But here we're asking them no more than Your Honor could have asked by polling them, which is, did you reach a verdict on count one? What was that verdict? What about count two? No. What about count three? Yes. So there is precedent, although slightly different, but we contend no less important, to Your Honor making a decision. If Your Honor is skeptical in any way of the attorney's declarations, if you cannot accept them because they're not the sworn affidavits of lawyers, of the jurors, sorry, we ask, authorize them to do what they haven't, which is to reinitiate a call to these 4 or 5 jurors, ask them whether they would read the lawyer's affidavits and affirm that they're accurate, or alternatively, authorize the lawyers to ask the jurors whether or not they would execute an affidavit. It could be 2 sentences. We reached a final decision unanimously to acquit Ms. Reed of counts 1 and 3. Your Honor doesn't have to accept 4 out of 12 or 5 out of 12. Your Honor has a lot of discretion in terms of how to get to the bottom line, which is what is the truth here. And Your Honor could schedule a hearing and have the 4 jurors in. They would remain anonymous. We would even waive public trial. I'm not sure if either of you would, but to keep this private and keep this confidential, because we don't want the jurors to, risk identity. Your Honor could do it in any number of ways. We have responsible court officers that can meet 4 jurors anywhere Your Honor selects. We have responsible lawyers and responsible prosecutors. This doesn't have to be an event that challenges the jurors' anonymity. I guess what I'm saying is that we're asking the court not through closing the door to this new evidence and really adopting a fiction that the impasse was on all 3 counts when we now know that there's strong corroborated, trustworthy evidence it was not, to establish a procedure consistent with McCulloch, consistent with Tsarnaev, consistent with the Supreme Court decision in Renner, and take those cases where jurors do come in after the fact, when there's credible, responsible evidence that they were either biased or that they had some extrinsic evidence, whether from the internet or from an improper contact with a third party, and help us investigate this. I don't believe that if the Norfolk DA was convinced from that process, and it could be 4 jurors, it could be 12, but if all of them tell the court, we made a final decision, we never went back, like the Bluford case, or to re-examine it, it was not an intermediate decision, it was a final decision. All of our impasse was about count 2 and the multiple lesser includeds. I am hopeful that the prosecution would join with us in not seeking a new trial if they were convinced by these jurors under oath to what they've not yet been convinced by, which is defense counsel. This was a hard-fought case, and I'm not being critical of the DA, but I've done this for a long time, and I believe in our system of justice. People say it's not perfect, but it's the best that the world has. This to me is hallowed ground in a courthouse named after someone who was a friend who I deeply respected. And I want the prosecutor to get the facts in the best way we can at this point in the case, which is through Your Honor. Order a hearing, Judge. Don't make Ms. Reed be the first person in the history of the Commonwealth to face re-prosecution for murder by the same prosecutor's office that tried her once and failed to persuade the jury she was guilty. They've not given a single case where facts like this have been ignored. Not a single precedent have they raised. Nationwide, state courts, murder cases, 50 states, federal, where there's been this kind of demonstration that we were silent when we shouldn't be, but she was acquitted. They've got the Commonwealth versus Juvenile, where there was a verdict slip, nobody knows when it was written. We have Bluford, but there was clearly further jury deliberation after a juror told the judge that we had reached a decision on 2 counts. I'm convinced, perhaps through many years of doing this, that acquittals count. And if she was acquitted, nobody wants her re-prosecuted on the counts for which she's been acquitted. And form's important, procedure's important, but what's more important is substance. What's more important is to find out whether that jury, in fact, voted to acquit and it was a final vote. And then I hope there's no dispute. I hope Mr. Lally will stand up in front of you and join me in asking that those 2 charges not be re-prosecuted. So let me switch from the acquittal, its implications, to manifest necessity. In this case, we have explicit guidelines, which have been set out by the Supreme Judicial Court, that look to whether or not there was manifest necessity for the declaration of the mistrial. Manifest is a word that says to show clearly, and whether the mistrial order was avoidable, whether there were any viable options, whether the court essentially had no choice, no options. And here at minimum, with 4 or 5 jurors saying, we believed her to be innocent, we believe there was a vote, there's no evidence from those declarations that there was an impasse on counts 1 and 3, an impasse that would have rationalized and justified the order of mistrial. The note, as I said, was believed to be unambiguous by the prosecutor, but in truth was ambiguous. It led to 1 or 2 constructions. So this is really becomes a burden of proof issue. Who bears the burden when there was an understanding by the court that the note reflected an impasse encompassing all charges, when we now know there was a rational alternative explanation for the note, a logical one, which is we were addressing only the charges in count 2, the multiple charges, the multiple decisions within the manslaughter count. Here's where the court helps us. The Supreme Court in Arizona v. Washington placed a heavy burden on the government, on the prosecutor, to justify a mistrial. The SJC has issued multiple opinions. And I'll read just a couple, because I think the burden of proof issue is central, Judge. Commonwealth versus Stewart, which goes back to 1985, was one of the central decisions that started formulating the jurisprudence around double jeopardy and manifest necessity, says the prosecutor must shoulder the burden of justifying the mistrial if he is to avoid the double jeopardy bar. His burden is a heavy one, citing to Arizona v. Washington. Cruz v. Commonwealth, SJC 2012. The heavy burden of proving that a mistrial was due to manifest necessity lies with the Commonwealth. Commonwealth versus Nicole, 452 Mass 816, 2008. The Commonwealth is unable to satisfy its heavy burden of proving that there was manifest necessity for declaring a mistrial, and the Commonwealth is therefore barred by the principles of double jeopardy from retrying Nichol. I have a copy of the Nichol decision because it's the one that was not referenced yet for your Honor's consideration. Nichol was an interesting case. It was a driving case, jury of 6. There was belief that one of the jurors should not be sitting because he knew a witness, if I'm recalling the facts correctly. And everybody considered it and thought there was no procedure to allow a trial to continue with a jury of 5. The defense counsel thought that, and the court thought that, and the court therefore declared a mistrial. Afterward, everybody discovered that this was in fact a rule of criminal procedure, and the defendants could waive a jury of 6 just like they could waive a jury of 12. And the court determined, as I just read, that there was no manifest necessity because there was a viable option to the declaration of a mistrial, that being the court could have asked the defendant whether or not they would agree to a jury of 6, but they didn't recognize it at the time. And then the court had a decision. Are we going to blame the defendant, make them go to trial a second time in the face of double jeopardy's manifest necessity requirement, or are we going to put the burden on the prosecutor to have advised us of that rule? This case is similar, Judge, because what you weren't advised of is Mass Rule 27B. See, everybody focused on Roth and Juvenile and Bluford, where all of them were single counts with lesser included. In the Roth case, the SJC decided that it prohibited judges like yourselves from inquiring into the vote. You couldn't ask the jury, well, if you haven't decided on manslaughter, what about involuntary manslaughter? What about OUI? But this is different because we had 3 counts, not 1. And Rule 27B that you were not advised of, and we contend, of course, the burden was on the table of the side that wants to re-prosecute her, says as follows. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree and direct that such verdicts be received and recorded. The advisory note is even more explicit. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must first receive and record the verdicts which the jury can agree on. That rule, had it been brought to the court's view, provided a viable option to a declaration of a mistrial. It would have justified the courts, it would have required the court, as well as justified, to ask the jury whether or not it was an impasse on all counts, or rather than just 1. So the Supreme Court not only puts the heavy burden on the prosecutor, it provides a set of guidelines which were established back by the Stewart case and repeated most recently by the Taylor case. And they even call them 2 principles guiding our review of manifest necessity. One is counsel must have been given, and the word must implies it as a mandatory, as an imperative. Quote, counsel must have been given full opportunity to be heard, and I'll address that second. And quote, the trial judge must have given careful consideration to alternatives to a mistrial. These are the legal imperatives, and we contend respectfully, for a variety of reasons, that neither of those 2 guiding principles were met by the evidence of what occurred on July 1, where we have the chronology, if Your Honor, taking argument from counsel regarding the warning note, and the prosecutor didn't want a TUI instruction, defense counsel did, Your Honor elected to give a Tui instruction. And 4 hours later, the jury sent a second note. And unfortunately, there was no convening of counsel and no request for counsel's position, no opportunity for Mr. Yannetti and Jackson to speak to Ms. Reed. After all, it's her rights, not just theirs. And there was this lack of consideration, careful consideration of Rule 27B, which the prosecutor failed to bring to the court's attention. Again, usually this would be an issue where the defense counsel could be criticized when they don't object to instructions after trial instructions. The Court of Appeals makes it very hard for appellate lawyers to succeed in reversing the judge's not providing an instruction that later they learn. But this is double jeopardy. This is different. This is why all of those cases, the U.S. Supreme Court in Arizona, the Supreme Judicial Court in Stewart, Nicole, the appeals court in a case, Commonwealth versus Oregon, we've cited. In light of the importance to the defendant the right to be free of exposure to second jeopardy, the burden of justifying the mistrial rests on the prosecutor. And so again, it's the default. If these procedural guidelines, these principles, where the court must consider any viable alternative, just the judge may not know every rule at every moment, just like the judge in Nicole did. It's on the Commonwealth to have advised you, Judge. So this was a case that really comes down to whether or not there could be deference to a judicial ruling when it was made without meeting the criteria, a full opportunity for the defense to be heard before the court read the final note and issued its final order, and a full opportunity for the court to consider the alternatives to the declaration of mistrial. I would say to Your Honor that this is not easy. This was a long trial. Prosecutors got strong evidence that the jury was in fact deadlocked, at an impasse on count 2. The prosecutor has strong evidence that in fact the jury was not at an impasse on counts 1 and 3. They have to meet a burden of demonstrating to the court that they gave you all of the alternatives to the declaration of mistrial. And they should want, I submit, in a search for justice in this courthouse, where we don't want somebody who's found innocent once to face the second trial for the very same offense. That's the whole principle, the centrality of double jeopardy, Justice Douglas and Black's words in Green. They should join us in asking the court to establish a procedure in Your Honor's discretion that either allows the defense lawyers to supplement the declarations with juror affidavits, or cut right to it, that the attorney declarations satisfy our burden of production. If Ms. Reed was acquitted, bring the jurors in, Judge, hear from them. Thank you. It's the right thing to do. Thank you very much.
Great, thank you.
You want me to hear or?
Wherever you.
Your Honor, I'm also would ask, request that the defendant's motion to dismiss be denied, as it was not a term. Counsel had more than adequate opportunity to be heard and object to the declaration of the mistrial in this case, and the mistrial was declared as a manifest necessity. To that last point, as it applies to what counsel was referencing in regard to Rule 27B, what I would submit there is there's a stark difference between what Rule 27B encompasses and what counsel is asking for the court to do. And what I would say is there's a difference between what Rule 27B talks about, which is taking, or the right of a court to take partial verdicts, which certainly the court is entitled to do. there had been any communication whatsoever from the jury that they had reached a partial verdict. So Rule 27B has to do with taking of those partial verdicts, not inquiring or trying to extract or coerce a partial verdict by polling the jury who has declared repeatedly to the court that they're in an impasse. So simply put, Rule 27B just does not apply. When it comes to each of those respective points, the jury in this case, when one, did not return a verdict, and two, counsel had adequate and ample opportunity to object to the declaration of mistrial, and three, that the mistrial was declared out of clear manifest necessity, which the court, the case law has repeatedly stated is the typical sort of evidence or example of what manifest necessity is. But to those points, it is backed by decades, if not centuries. Does quite a twisting of logic into sort of a pretzel in order to have the circumstances of this case fit into the precedent. There's a reason for that, because there is clear and unequivocal precedent on each of those points that goes back decades, if not centuries. Commonwealth versus the juvenile is a case directly on point. And as the court is well aware, that's a case in which, following jury deliberations and the defendant having been convicted after trial, one of the court officers found a verdict slip in the jury deliberation in which the verdict slip was marked not guilty. That case stands for the proposition that where those slips were in contradiction of the jury's report to the judge in open court, that they were deadlocked, that does not guilty finding on the verdict slip does not contravene or overrule the verdict as it is applied in open court. We're quoting from that case, and I think it's directly applicable to what's been provided to the court so far. It states, it is not enough to show that the jury may have agreed on some issues at some time. If that limited showing were to control, uncertainties would be invited. And that's exactly what the defendant is asking the court to do in this case, is the contravention to that case law in juvenile, in blue, in Roth, in Gray, in all of the cases over the decades and the centuries dealing with this. Blueprint itself states very clearly, the very object of the jury system, after all, is to secure unanimity by comparison of views and by arguments among the jurors themselves. A single juror's change of mind is all it takes to require the jury to reconsider a greater offense. And that also comes in Commonwealth versus Carney as well. But what it states, Your Honor, this jury was instructed, not only instructed orally for a lengthy time, but was provided with written copies of those instructions that the court gave. That stated on at least 9 or 10 different times exactly what a unanimous verdict was and how to come to that unanimous verdict and how to report that unanimous verdict. And there is no verdict that was returned stating anything in this case. And in particular, the two charges that the defendant now complains of dealt with simple choice. There was a box for guilty and a box for not guilty. Neither was checked, neither was returned to the court at any point in time. There is no verdict in this case. Now, as far as whatever those communications that the jurors are referencing, what the Commonwealth was doing, Your Honor, is the jurors did nothing wrong in this case. The court did nothing wrong in this case. The court applied the law as it exists to this case. There's nothing special about this case. There's no special application or procedure that needs to be developed, created, or employed as it applies to this case or this defendant. This defendant, in this case, should be treated as any similarly situated defendant or any similarly situated case within the court system. These jurors, as the courts refer to them as an extraordinary jury, and I know the court had opportunity to observe the jury throughout the course of the lengthy trial and to review the many communications that the jury submitted to which Commonwealth would submit were thoughtful, were deliberate, were intelligent, were insightful. This jury told the court on multiple times that they had reached an impasse as far as their deliberations were concerned, as it pertained to the charges. In the final note that was submitted to the court, they refer to the charges in the plurality, plurality, twice within that minute, as it pertains to exactly what they were stopped. When it comes to what they were communicating and reporting to be at an impasse in regards, they refer to it as charges multiple times. Whatever point jurors may have felt, the other thing I would say about the jury is, and this goes to the precise reason of why the procedures suggested by counsel are completely inappropriate in direct contradiction of what the case law says. I can't imagine whatever the jurors have undergone since July 1st, as far as extraneous influences, whether they be personal, professional, who they talked to, what they talked about, how those things have formulated in their minds. The intense pressure that they felt, just looking at the affidavit from the one juror in regard to the comment that the court had allowed with reference to the jurors' information remaining anonymous, at least for the time being. With respect to that, that is exactly what the case law advises against and governs as far as taking this sort of post hoc, weeks or months after a verdict has been returned or not returned, and then asking people to put themselves back in a position and indicate to the court exactly what was going on in that deliberative process. Asking them how they voted or what their vote was is infringing into that deliberative process that is specifically excluded from any sort of point of contention or inquiry by counsel, by the court, at any point in time. When it comes to the adequate opportunity that counsel has to object or to suggest anything else, this is the very first time that the jury gave any sort of note or indication beyond the first note asking for a report. Mr. Yannetti was asking for Tui Rodriguez. And understanding that asking for Tui Rodriguez is not equivalent to requesting a mistrial. It's the first step in that process, and experienced counsel knows that. And even in that first note, the jury had not indicated that their deliberations were done, that they had done thorough deliberations. They weren't asking anything. They were just reporting to the court simply where they were in their deliberative process at that point, reported to be at an impasse. Counsel, and these are Mr. Yannetti's own words, on both occasions, indicated that from them, or argued for Tui Rodriguez on both of those first two notes that came from the jury, that this jury was emphatic and that they were, quote unquote, hopelessly deadlocked. That is what counsel was asking for. What counsel is intimating there and making an argument about is for mistrial at those particular points, or at least leading down. Now, as far and this is also, again, as I stated, backed by the case of Ray versus Commonwealth states. Counsel's request for Tui Rodriguez instructions permits, quote, the inference that both parties were provided an opportunity to confer on possible alternatives to mistrial. Almost Ferrer versus Ferrer is on point with that particular point as well. And I think it's also important to consider this in the context of this particular case and this particular trial. This is counsel who was not shy, did not have any misgivings about presenting any sort of argument or any sort of argument against the court's decisions when it came to anything that was even a perceived slight measure against the defendant's interest. And I would direct the court to the verdict slip argument that was made post-trial as well. Getting to the manifest necessity, Your Honor, as I stated, what the case law clearly states is that a prototypical example of the manifest necessity is a deadlock or a hung jury. And that is what we have in this case. It's clear, unambiguous from all the communications, even Mr. Yannetti during his arguments for the two Rodriguez recognized the same. The dangers of coercion when it comes to a deadlock jury are amply stated throughout the case law, as far as Ray, as far as Cruz. The court was never required and has never been required, and that goes from the Cooper decision from the United States Supreme Court to the Supreme Judicial Court of this Congress, that there is no requirement that the court makes any sort of polling or has any sort of asking when it comes to those, how the jury stands, or whether or not they have a vote, or whether or not they have a partial vote. I would also submit, Your Honor, that counsel's argument is a little disingenuous when it comes to indicating that those cases only apply when you're talking about charges with lesser included, or charges that have a multiplicity of different findings that the jury can make, because it ignores the fact that there are those two, and the two very charges or indictments that the defendant is seeking to dismiss here were very simple. Not guilty or guilty. Those are the two boxes to be checked. So in those instances, it may be permissible for the court to require a poll. But the coercion and the fear of that that's developed through the case law is inherent within the second count, which had all of those lesser included charges, which is exactly what the case law and the rules prescribe, as far as not allowing for the court to inquire into those types of scenarios. So, yes, the defendant's position is the court should have polled or inquired only as to indictments 1 and 3 and not to as indictment number 2. But again, I don't know if there's any requirement for the court to do that. I don't know exactly how the court is to do that when it comes to those types of coercive pollings of the jury while they're still deliberating. The notes and the communications from the jury, again, on 3 separate occasions, in a very deliberately, as far as the language that was used, declared themselves to be at an impasse on 2 separate occasions, the last of which included language to the effect that any further deliberations would be futile. That is the very definition of manifest necessity, and left this court with absolutely no alternative other than to declare mistrial. And that is clear from the language of the jury's communications to the court, and it's clear from the case law and the rules and the law itself as far as what the court can do. The 2 areas that counsel is talking about and sort of asking for extension or creation of new law, again, sort of special or deferential treatment to this case or this defendant. The 2 areas in which the court can make post-trial inquiry have to do with some sort of bias, if there's an issue raised in regard to whether it's due to racial discrimination, gender discrimination, or some other protected class. So that sort of bias implicit in the jury's deliberative processes, or in an instance, in an instance in which there is some sort of allegation or some sort of evidence of extraneous influence. The defendant's not raising either of those issues. Specifically within those cases, what the court states, which is obviously binding on your own, is that those carve-outs for extraneous influences or bias on the parts of the deliberating jurors are permissible areas for post-trial inquiry. What all those cases also say is any inquiry into the deliberative process or exactly what counsel is proposing here is specifically prohibited by those cases that have developed over the decades. Commonwealth versus Moore states specifically that Massachusetts continues to adhere to common law principles barring inquiry into the contents of jury deliberations and any impeachment of jury verdicts based on information gained from such inappropriate inquiry. Now, the reason that the Commonwealth did not respond directly to the jurors when it came to them expressing or wishing to have discussions about their deliberative process or their votes is specifically for the Rule of Professional Conduct 3.5C states specifically that inquiries into those topics are not allowed. The case law that is derived around that and since that corroborates. Simply because someone called you first does not then allow for that inquiry to occur. So whether or not you initiate the call to the juror or the juror calls you, it still does not allow for counsel or the court to then have these conversations with these jurors that delves into their deliberative processes or their deliberations. The specific type of coercion that is feared by the courts when it comes into this, and sort of condensed quote from Commonwealth versus Will. And it states simply, one cannot assume from the mere report of deadlock that there is any final verdict lurking within that deadlock that may be extracted. Such inquiries of the jury may succeed in extracting a partial verdict, but we could not have confidence that that partial verdict was the product of a thoughtful and thorough deliberation process. The risks of jurors' coercion are too high, and the reliability of any such partial verdict returned is too low to warrant such an approach to salvaging some partial result from a deadlock jury. Simply put, Your Honor, what counsel is proposing as far as what the court should do is prohibited by the rules, it's prohibited by the law, it's prohibited by the development of case law over decades and centuries as to what is permitted. Certainly, the Commonwealth nor anyone wants to try someone who has been acquitted by a jury of their peers or retry them on the same case. That's not what happened. There was no verdict returned by this jury. Counsel had more than an adequate opportunity to address the court in relation to the declaration of this crime. And the court did absolutely nothing in finding a manifest necessity as the only alternative that could have been employed in that particular case. Polling the jury then, polling the jury now. It's simply not permitted by the rules, it's not appropriate, and therefore the defense motion should be denied. Thank you.
Can I reply, please? Thank you. There were two cases that Mr. Lally relied on, and they both stand for very different propositions of law. Commonwealth versus a juvenile, it's actually juvenile versus Commonwealth at 392 Mass 52, 1984. Says the judge was under no duty to inquire as to the status of the jury's deliberations on each of the lesser included charges within the murder complaint. Footnote 1 of that opinion says, quote, we deal here with a complaint charging a single murder, where a complaint or indictment in multiple counts charges multiple crimes, e.g. two separate murders. A general verdict could be returned as to one of the counts, despite deadlock on other counts. Commonwealth versus juvenile was as if count 2 in this case was the only count, and they discouraged any kind of court questions as to where the jury stood on lesser included. And that's the principle of Commonwealth v. Roth, the other case that Mr. Lally referred to. That case created a dichotomy where the court was asked whether or not a judge was permitted to ask the jury about lesser included. And because of the fear that a court's mere question could have a kind of domino effect in coercing jurors to reach compromises as to lesser included, the court prohibited such questioning as to lesser included. But the court distinguished throughout this lengthy SJC opinion. Our case, we're not dealing with one count vertically with multiple charges, we're dealing horizontally with 3 separate charges. Both Buford and the juvenile had evidence that the unanimous verdict that the defense was claiming occurred before the end of deliberations. In the juvenile, I think weeks or days later, according court officer found some verdict slips. Nobody knew when they were written. In Bluford, the Supreme Court case, where there was a statement to the court that we've reached a decision on one count, the court sent them out under Arkansas law because they hadn't decided, just what they were. They needed to decide all of the different allegations within a single charge, and they came back and said we're deadlocked on everything. But there's no risk of jury coercion when a court is asking the jury whether they reached a verdict on other charges other than the one they were deadlocked on. There's no risk of jury coercion saying, does your note reflect all charges rather than one? Your Honor instructed the jury, page 46 of the instructions, you should continue deliberating until you have reached a final verdict on each charge. We don't know whether the jury understood that instruction to mean that we can't come back and tell the court affirmatively that we've reached two decisions, two general verdicts, but we're in an impasse on a third one. The Commonwealth talked about the risks that some of the jurors might be exposed to media, and that's certainly more than true in the Salayev case, where they've had just an overwhelming amount of media regarding the catastrophe at the Boston Marathon in 2013, the government's investigation, the trials. Jurors knew what one jury decided, and yet the First Circuit said that's not a prohibition about a court exercising authority to ask the right questions. Judge, you're an experienced jurist. I trust you to be able to determine whether or not a juror telling you they reached a verdict, to determine whether it was final or whether it was somehow influenced by the media. Your Honor does that every day when you pick jurors on the front end to determine whether they're biased or unbiased. It's certainly not a prohibition that should insulate an acquittal and allow a re-prosecution. The question at the end for the jurors would not be about the deliberative process. I understand Mr. Raleigh's citation to Moore and the discomfort and the rules that say jurors should not be asked questions by anyone regarding, why did the Commonwealth not persuade you that Ms. Reed was guilty? Or what did you think of this witness's credibility? Or why did you vote a certain way? Or what did the other 11 jurors say? A deliberating jury is not a focus group. It's not a place, for lawyers to ask about the views of 12 jurors, through the interview with one juror. But Your Honor is being asked to do no more than ask them what you would ask if they came out and said we have a verdict, which is, did you unanimously determine as a final determination that Ms. Reed is innocent of counts 1 and 3? Was your decision unanimous? Did any juror dispute it? That's very different than probing the subjective state of mind or probing for what other jurors said that caused somebody to reach that unanimous verdict. If Mr. Lally's concerned it wasn't a final verdict, Your Honor can ask the question, was it a final verdict? Was there ever a deliberation again after you reached that unanimous decision? In terms of the argument about Tui and Mr. Yannetti saying, well, they're deadlocked, if he wanted the mistrial, he could have asked for a mistrial then. Your Honor would have, of course, had the discretion to deny it after 4 or 5 days of deliberation. He asked for a Tui instruction. And it's inferred by a Tui or a Rodriguez instruction in the state court. Tui, I think it's a 19th century federal case, is that you have hope when you're asking for the Tui instruction. My experience, usually the prosecutor who's confident in the jury that wants the Tui instruction to try to get the majority to overcome the minority and get to a guilty verdict. Here you have the defense lawyer asking for a Tui instruction, reflecting that he wanted further deliberations. And so it's no answer, and the Ray case does not say that when you ask for a TUI instruction, you are really asking for something more than a TUI instruction. TUI means, I want this jury to reach a decision. And that's what Mr. Yannetti was saying during those two colloquies on the Friday before and then on July 1. We're not asking the jury to impeach a verdict. We're not asking for an inquiry that would be prohibited. I know the federal rule is 606B. I think the state number might be about the same way in terms of asking the jury for their state of mind. We're asking the court to conduct a voir dire that Mr. Lally agreed would be done if our argument is one of the 12 jurors was biased. If our argument was, well, we now have new evidence one of the jurors read on internet. We have evidence here that the jury acquitted Ms. Reed. What can be more central to the core values of our criminal justice system than to make a judicial determination with a respected and experienced Superior Court judge, whether that's so or not, and if it's so, stop her re-prosecution, because that would be a horror to make her convince 24 jurors of her innocence, a second 12 when she's already convinced the first 12. Thank you, Judge.
Thank you. Any response, Mr. Lally, or are you all set? All right, thank you very much. I'll take this under advisement.
Thanks, Judge. Judge, when I hand the Nicole case to you.
Sure, thank you.
Okay. So that's basically a PR stunt, in my opinion, for Karen Reed. I don't really think they have a chance in heck of getting that Karen Reed's case dismissed on these juror charges. And, you know, it was an interesting part of Martin Weinberg's argument where he said, well, you know, we could bring 4 of these jurors in. Why not 12? Why don't you want to bring all 12 in? And interestingly, Aidan Carney has said that he has heard that they're looking into him. This is what he says, for witness tampering. I mean, juror tampering, excuse me, witness. He already has 19 charges for witness intimidation. So what happened here with the jury is would be very interesting to find out. Did some free Karen readers get on the jury? There's a lot of stuff going on in Karen Reed. I haven't gotten back, took a little break from it. But a lot of stuff going on with just the free Karen Reed movement that I'd like to talk about. I may talk about it tomorrow and her case, but this is a PR stunt to make it look like it's so obvious a case and that the state is, or the Commonwealth is just so insistent on retrying such a weak case. LOL. There's more evidence against Karen Reed than most of the cases I talk about. So that's what I have to say. Have a great day, everyone. Thanks for watching. And I'll see you guys tomorrow at 6 p.m. Eastern.